The administrator's interpretation talks about two different types of joint employment. The first is vertical joint employment, which typically involves a relationship between a company and its vendor and the vendor's employee. If that relationship is strong enough, a joint employment relationship may be inferred by the wage-hour division. The second type of joint employment relationship is a horizontal joint employment relationship, which involves relationships between two separate but related companies that are employing the same individual. In that case, if the relationship between the two companies meets certain criteria, then the employee can be found to be a joint employee of both companies. And that can be problematic because if the employee is working 25 hours for one company and 25 hours for the other company, well, once it's found to be joint employment, the employee's worked 50 hours and may be entitled to overtime. One notable aspect of the administrator's interpretation is it talks about the fact that joint employment relationships often arise between large companies and smaller companies, usually vendors. And the wage-hour division made it clear that if there's some sort of liability that arises from the joint employment relationship, the wage-hour division can pursue financial recovery against either company, even if it's a smaller company that's clearly responsible for the violation. And that doesn't mean that companies shouldn't be working with vendors or their employees, but they need to be careful about selecting vendors who are mindful of their legal obligations and complying with the law. Employers need to continue to be mindful of whether or not they're controlling employees of their vendors, whether or not those employees are economically dependent on the customers. They need to consider whether or not they really want to be sharing employees with related companies. But most of all, companies just need to be careful that they're selecting vendors who are quality, who are reputable, who will enter into indemnification agreements in the case that any joint employment relationship arises and is found to create liability, and then who actually have the financial commitments or the financial resources to meet those commitments.